Ladies and gentlemen, welcome to the launch of the QLRC's review of evidence law in Queensland. I'm really delighted to welcome so many people, firstly, to our offices. We haven't had an event like this here before. We're testing our facilities and it's pretty much standing room only. Thank you for coming. And online, I think people are still joining, but we have more than 350 people who have registered to watch this launch event. No pressure, speakers. We kept that quiet so that they didn't feel any pressure in the lead up to this event. We've got many people who are attending who hold senior positions within the profession, of course, but time prevents me acknowledging you, and I hope that you will forgive me for not doing so. Everybody is welcome, and I mean no disrespect. I'd like to briefly introduce our three panellists. Ms. Ruth O'Gorman, who's a preeminent senior criminal barrister in Queensland, and she's a member of the Queensland Law Reform Commission. Justice Lincoln Crowley, he's a judge of the Supreme Court of Queensland, and for me, more importantly, he is a member of our Aboriginal and Torres Strait Islander expert legal reference group. And Dr Rebecca Wallis, who is a senior lecturer at the TC Byrne School of Law, and her teaching and research scope is really on point for this review. It includes law of evidence, and you can see that we have chosen a panel that will bring different perspectives to this most important topic. Before we go any further, I would like to invite Justice Crowley to acknowledge the traditional owners.
Thanks, Fleur. I acknowledge the traditional owners of the lands on which we gather today, the Turrbal and Yagara peoples. I pay my respects to elders past, present and future. I also acknowledge and welcome all Aboriginal and Torres Strait Islander people who are present here today or with us online.
All right, now the purpose of a launch event obviously is to inform you about our review, but it's more than that. What we're hoping to achieve from this exercise, particularly some months into our review, is really to ignite your interest. And I think that just the response to the launch event suggests that that objective has already been achieved. So ignite your interest, but also to encourage you to engage with us during the review, because the more participation we have from those who have experience with evidence law, the better our work will be. The format that we will use is that each speaker will speak for about 10 minutes, and we'll hold off any questions until we get to the end of the speakers, if you don't mind, because we do have a Q&A at the end. So the speakers will address you in turn, and then we'll have a Q&A session. Because of our numbers, both here and online, and the time, it's a lunchtime event, we probably won't get to do more than a few questions from the room and from online. But we have got a plan to capture your questions and to answer them later to the extent that we can at this stage of the review. So for those of you who are online, you're all muted and you will be throughout, but you have a chat function. If you open your chat channel, you will be able to see what other people are asking and saying, and you can add to that. Those of you who are online, there will be an opportunity at the end to ask questions or to make comments, and we'll also dip into the chat and perhaps raise a couple of things that come from that. Later, what we hope to do is to gather together, and we will do, is gather together all of the questions and comments that we get either during this session or later, because this is being recorded. We're going to send you an email with the link to the recording, and that will be another opportunity for you to either pose a question or ask or make a comment. And in time, we will synthesise that and we'll produce a paper that you will be informed about, which addresses the themes that have come from the questions and the comments that we've received in response to this event. So all of that will be happening after today. So don't think if your question isn't reached, that's the end of it. I would like to Oh, I suppose before I introduce any speaker, I should do the housekeeping. This, I think, is a health and safety requirement. Now, you came through a corridor to get here. That's where the toilets are. The doors are open, so you can make your way there if you need to. And if you need to evacuate, Jodie, where are you? Jodie with the red hat raised. She's in charge. Just follow her directions. Generally, I find that works well for me in the office. So I'm sure it'll work well for you. But for now, I invite you to sit back and listen to our expert panellists address evidence law in Queensland. And we'll start with Ruth O'Gorman. And she wears two hats today. In one hat, she's no stranger to, certainly those of you I look around the room, you will all know Ruth. Because of her work, she's one of Queensland's most sought after criminal counsel, in my view. But she also has extensive experience in inquiries and other processes, not just criminal trials. Most notably, I think, the police responses to domestic and family violence. We have asked Ruth to address as in her role as Commissioner, though, of the Queensland Law Reform Commission, how the Commission is approaching this review. So her focus today is to wear that hat as a Commissioner for the Queensland Law Reform Commission, and I'm sure you're not surprised that she brings to that role her intelligence, but also an integrity and a willingness to give, which I certainly appreciate as Chair of the Commission. But she will also bring a practising barrister's perspective to the topics that she will address. Because Ruth will use a few slides, I'm going to stand over here, so don't think I'm just being awkward. So it may look awkward, but over to you, Ruth. Thank you.
Thank you so much, Fleur. It's really nice for me to have the opportunity to kick off this discussion this afternoon about the evidence law review that the Commission's going to do. I've had the really good fortune of being on the Commission on two separate time periods and have had the opportunity to sit in and contribute to a number of different reviews that the Commission has done. And I think that this one is particularly interesting and is particularly exciting. So I'm very happy to have the opportunity to talk with you this afternoon primarily about what the review is, why it's important, and some of the processes that we're going to use moving through the review. As many of you would know, the terms of reference for this review were given to the Commission by the Attorney-General in December of last year, and as Fleur has mentioned, the Commission's already been working for a number of months on the review. The scope of the review is to consider the operation and suitability of the Evidence Act 1977, the Queensland Evidence Act. The overarching task of the review is set out in paragraph 2 of the terms of reference, and they're replicated there on the screen. The Commission, as you can see, is asked to undertake a review of the Evidence Act that considers the need to modernise and simplify the Act to ensure the effective administration of justice in Queensland and the protection of victims without reducing existing rights or safeguards. It's a big task and a really important task. I say it's important because evidence law is not only a list of technical legal rules, it is the overarching mechanism by which our courts can reliably, fairly and efficiently deal with all of the disputes that come before it. As a community, of course, we want the outcomes of both criminal and civil matters to be determined on evidence which is relevant, reliable, and fairly obtained. Over time, our understanding, that is our understanding as a society, as a collective, about what evidence is reliable and relevant, change. Also, our notions of what is fair mature over time. And so, of course, if the law is to keep a pace with community development, it's really important that reviews like this occur periodically to ensure that the laws continue to serve the community and are fit for purpose. From my point of view, in my work as a barrister, the laws of evidence really govern almost everything that I do. They set the framework, the guideposts, as it were, for how I present a matter in court. They govern how I go about even preparing a brief right from the time that I receive it, because knowing what the laws of evidence are mean that I can work backwards from that knowledge with the facts that I have, applying them to the laws that I know are going to govern the particular matter that I'm involved in, which will in turn govern the strategy with which we might use as a legal team to progress the matter to get the best possible outcome for a client. So certainly from a barrister's perspective, a solicitor's perspective and a judge's perspective, the laws of evidence really govern everything that we do in our day-to-day life. The other thing that I would say from my work as a barrister is that I really get a front row seat to observing how the laws of evidence affect witnesses. I'm in the courtroom when I see witnesses being examined and cross-examined, and I see how hard a job it is. I've had the unfortunate experience of being a witness myself and was really surprised for someone who's in court all the time just how daunting a process it is. But I do get to see that in action. And so I know, as any other barrister, solicitor or judge would know, just how important this review will be to ensure that witnesses continue to be treated fairly in the courts. I would say that this review is not only timely, but arguably long overdue. And to make good that proposition, I need only give the briefest of potted histories of evidence law in Queensland. It was in 1859 that we separated from New South Wales, and common law governed evidence laws in Queensland from that time. In 1867, we introduced the Evidence and Discovery Act, and that act remained in play for more than 100 years. Over the course of that 100 years, there were other acts which were introduced which dealt with evidence law, but they didn't comprehensively codify the law in any way. Then in 1975, the Law Reform Commission completed a review of evidence law, but that review was really looking to consolidate the various acts that were in place at that time and modernise the wording in what was the Evidence and Discovery Act for the purposes of introducing the Evidence Act of 1977, rather than to create any wholesale change. Since 1977, there's been a number of amendments to the Act, but they've been largely responsive or reactive to particular reviews that have taken place. And so the changes have been quite disparate at times and there hasn't been an opportunity in this state for there to be a wholesale review of the Act and how it works. It's a welcome review because it will give the opportunity to consolidate the various acts that still govern evidence law in Queensland. Of course, we know that the sources of evidence law are vast here. We have the common law, we have the Evidence Act, the Criminal Code, there are various other acts that touch on evidence, the Uniform Civil Procedure Rules, the Criminal Practice Rules, and a number of practice directions. From a barrister's point of view, that can be difficult, knowing that you have to go to so many different sources to try to understand the evidence law that might operate in any given matter. So the opportunity to potentially consolidate some of that is exciting. With respect to the terms of reference, you'll be able to have regard to those, and I won't go through them in detail. Suffice to say that they are extensive and will allow a really thorough review of a whole lot of topics, including cross-examination and examination of witnesses, admissibility of evidence, and really important topics such as hearsay evidence, the opinion rule, and the tendency and coincidence rule. They will all come under review as part of this. We have on the screen here the guiding principles which will govern the review that we do. They're essentially going to serve as a touchstone for our review and to make sure that as we're considering submissions and considering proposals, we use this as a way of ensuring that we keep ourselves on the right track. We think that, put simply, the laws and any amendments to them should make sure that the evidence law is fair, effective, clear, and enduring, fit not just for now, but well into the future. One of the big questions that we are asked, the Commission's asked to do in this review or to grapple with, is whether or not more or all of the uniform evidence law should be adopted in Queensland. And that's an exciting question as well, because the Queensland Law Reform Commission hasn't previously been asked to recommend whether or not to adopt the UEL before. By way of very brief explanation, the UEL essentially came into being because the Australian Law Reform Commission drafted a model uniform evidence law in 1985. Then in 1995, the Commonwealth and New South Wales parliaments passed Uniform Evidence Acts. And in the 30 years since then, most states and territories have followed suit. This map demonstrates the adoption of the Uniform Evidence Law across Australia. The little line around the whole of Australia indicates that the Commonwealth has adopted the Uniform Evidence Law, and that applies in federal courts in all states and territories. And as you can see, Queensland and South Australia are the only states not to have adopted it. Western Australia, most recently, joined the Uniform Evidence Law states last year in 2025. Our approach is going to be to start by valuing the principles or the drivers of uniform evidence law, being to achieve consistency and harmony where possible. And our approach will be to see, by comparing the law as it exists in Queensland with the law that exists in the various states and territories under the Uniform Evidence Law, where there are deficiencies that we can build upon and where there are benefits that we can benefit from. We have, of course, the benefit of decades of operation of the UEL, and we'll be drawing on all of that. I'm going to finish up by simply drawing your attention to the timeline of the review, where in April 2026, the first of our background papers has been released, and there will be more to come. They will address particular key issues that we see will require consideration in this review. There'll be a period of public consultation. In April of next year, about 12 months from now, we will release a consultation paper and a draft exposure bill, because the terms of reference require that if we recommend any proposals for change, that we draft a bill to reflect that. And so we propose to put out into the community a draft exposure bill, which people will be invited to comment on and make submissions with respect to until June of next year. And then the final report and recommendations will be deliverable to the attorney in December of 2027. That might be all I can cover for now. Yes, thank you, Fleur.
I'm sure you'll have an opportunity to say more when we get to questions. Thank you so much for that, Ruth. That was a great orientation. And now we're going to go to Justice Crowley, who is a man with many firsts. He was the first Indigenous person to take silk in Queensland, and he was the first Indigenous person to be appointed to a superior court in Australia. As I said, I particularly value his role as a member of our Aboriginal and Torres Strait Islander legal reference group. And it was that led me to tap him on the shoulder for this review. I think that Justice Crowley will bring all of his experience, both as a practitioner and more recently as a judge, to bear in talking to us today about the purpose that evidence law serves in our system of justice. And if we're lucky, I think we might also hear from him a few thoughts on what he thinks works well and perhaps what might need a little bit of a freshening up. So over to you, Justice Crowley.
Thank you, Fleur. Yes, I'm very pleased to be part of the launch today to speak to you about one of my favourite areas of the law, evidence law. Who would have thought it's so exciting? Looking at the numbers of people, there's quite a lot of interest. As a barrister, I was fortunate enough to practice across every jurisdiction in Australia, in all states and territories, and I appeared under all the different regimes of evidence law, including those that had adopted the Uniform Evidence Law and those who had not yet adopted it but were in the process of adopting it. So I got to see the transition and the development of the evidence laws in different states and territories and how that was implemented and how it affected the profession, practitioners, the community and the courts. So that was a very good introduction to me in what happens outside of Queensland. And as a judge, I now have the opportunity to apply evidence laws on a daily basis in my role on the bench, and am keenly interested in the way in which evidence laws are used in our courts. This is a timely review. Ruth's outlined the history to date of the laws of evidence in Queensland, and they are in need of overhaul and a comprehensive review, particularly to clarify and simplify the law and make it comprehensive. Ruth touched upon the purposes and the guiding principles of the Commission's review, and in particular stressed the importance that the evidence laws must be such that they will enable the fair and effective administration of justice in Queensland. And thinking about that, there's a number of different strands to it which, to my mind, stand out as the things that really need to be considered as part of the review, and for those people who are participating to think about how they might put forward submissions, recommendations or ideas about the areas that the Commission would consider and how reform might be brought. So the first thing is that the evidence laws need to be coherent, clear and accessible for all people. Courts, lawyers, litigants, general public. Now that might not be the state of the law at the moment in Queensland. The background paper that's been released, if you have a look at page 14, I did laugh about it. There is a diagram there of the chaotic cosmos that is the universe of law on evidence in Queensland, and it's all the different planetary bodies floating around the Milky Way, which is at its centre the evidence law in Queensland, the Evidence Act, but all the other disparate pieces of legislation and sources of evidence law. That's a very good illustration of the state of the law. I tend to think of it more as a patchwork quilt, where different patches have been sewn on at different times using cloth from different eras, which has all been put together. It still doesn't make a full blanket. There's holes in it, and if you look close enough through the holes, you can see the underlay of the common law peeking through, which is even older still. So we really do need to look at a way of having one comprehensive review and one comprehensive source. Now, how that would be, it might be that it's going to be in a single statute, an Evidence Act, one that's modelled on or perhaps even adopts in whole the Uniform Evidence Law. That's one option. It might also be that we split part of what we have as the current evidence laws within that universe between those which are really more fitting to deal with proof and admissibility into one section, and in another statute we have the procedural measures which have been adopted over time and form part of our Evidence Act that we have now. So in other jurisdictions that's been separated between a Uniform Evidence Law Evidence Act and a Criminal Procedure Act, or in Victoria they have a Jury Directions Act as well to add on. That might be an option, something that the Commission would look at. The way in which the law is developed though in that sporadic way has led to it really being in different phases, different focuses depending upon whatever issues might be relevant at the time or policies that might be pursued, and often driven by other reviews or other interests which have piqued either government or members, parts of the community, which have led to the different reforms to date. If you look at the Evidence Act now in Queensland, another analogy, it's a bit like alphabet soup. There's so many provisions now which have an extended number of letters on the end to accommodate where they fit within the structure of the Evidence Act, to try to keep the form of the Evidence Act as it currently stands by accommodating these with more and more letters on the end. That doesn't necessarily mean that we would need to do away with those laws simply because of the difficulty in keeping track of the letters, but it does mean that it does make it a little bit hard to sometimes access and to understand where to find the relevant laws on a particular subject. The next thing to think about is that the laws of evidence need to be logical. Logical not only in their content but also in their structure, and this touches upon that same alphabet soup idea. The Uniform Evidence Law jurisdictions that have an Evidence Act based on those provisions, it does follow a logical structure which has much to commend it. So it follows a format which takes somebody looking at the Act through the way in which evidence would be introduced in a proceeding. So through what is, who can give the evidence, when evidence is relevant, how it's admissible, and through to discretionary exclusion. So it follows the format in which, the way in which issues would arise for consideration. And it also comes with a little navigation table which gives you the overview, which makes sense as well. In contrast, we don't have that overarching logic to our evidence laws in terms of a structure. We have the disparate pieces of legislation and other sources of evidence law which we need to navigate through to find the relevant laws, and that does get in the way oftentimes in how we approach the laws of evidence, how we apply them, and the consistency in which they may be applied. That brings me to two more points which go together. The evidence laws have to be capable of being known and understood by the courts, lawyers, litigants, and the general public. And they also have to be capable of consistent application. So much of what I've said touches upon those issues as well. But if we had everything in the one statute, or perhaps two, but let's say one statute where everything was covered, then we would have one comprehensive piece of legislation that would promote consistency. Everyone would know where the rules are, what the rules say, and then how they might be applied. There are currently difficulties in that approach given the way in which the evidence laws are in Queensland. That's a difficulty not only for practitioners and the public, but it's also a difficulty for the courts. One particular example, which until recently was a very difficult and complex area of law, it still is, but at least it's now written down, is the tendency and coincidence rules. So the similar fact and propensity evidence laws that previously applied according to the Fenig test made it very difficult not only for practitioners to be able to articulate a case, identify how evidence was to be used in a case and what purpose it would go to in a proceeding, but also for the courts to be able to understand how the evidence was to be relied upon, what its probative value was, and how it could be relevant and admissible in a proceeding. That's now been overhauled now, and we have had a new Part 7A included in the Evidence Act in Queensland, which is one particular example of the Queensland Evidence Act slowly digesting and morphing into the best parts of the Uniform Evidence Law. And one of the questions the Commission will have is whether similar things might happen. There's a need also to modernise the laws in Queensland. We have many provisions in the Act which are outdated from a different era, different thinking, different social outlook, different context and different technology. We now have routinely cases involving electronic communications, electronic and digital information. We don't need to have large provisions of the Evidence Act which deal with outdated photographic machines and how reproductions might be able to be admitted, notwithstanding that the colour hasn't been reproduced accurately and faithfully. We have no need for those types, but we do have need for other more broader and generally flexible provisions. The final area I'd touch upon is the opinion evidence and opinion rule. Under the Uniform Evidence Law, they have the advantage of having a single stated rule with exceptions which are clearly defined. We have in Queensland the common law, but the common law itself has also largely morphed into following the Uniform Evidence Law jurisprudence in the area, so that it's almost indistinguishable now, the test that we might apply. But there are some exceptions under the Uniform Evidence Law which really have an advantage that we don't have here and we would still struggle with. but one in particular is under the Uniform Evidence Law, Section 78A, as an example, which is the exception for Aboriginal and Torres Strait Islander traditional laws and customs, and that allows that the opinion rule doesn't apply where evidence is given by an Aboriginal or Torres Strait Islander person about traditional laws or customs. And that's an example of a way in which there's been a rule which has been modified by the statute to keep pace with modern times, modern ideas and modern society, and to enable the evidence that would be relevant and admissible, and there's no real concerns about reliability, to be accepted in a court proceeding. So that's my brief overview of some of the issues that I think raise on this review, and I would encourage everybody to participate, get involved, because the Commission's work will be enhanced by the more people who have input in helping the Commission's work.
Thank you, Justice Crowley. There is so much in that, and I know that there is more that you could and would like to say, and I can assure you all that we will be capturing all of that thinking that Justice Crowley has put into presenting to you today. I'm going to turn now to Dr Wallis, who is going to look at evidence law as really a regulatory system, and she's very well placed to look at that both in terms of trial processes but also pre-trial processes. Some of you may be aware that she formed part of the evaluation team for the video recording of Evidence in Chief pilot. So she has already got the runs on the board in looking at our evidence law from that evaluation of how it is operating in practice. So, Dr Wallis.
Thanks very much, Fleur. Look, I'm going to spend the next 10 minutes talking about three things. I'm going to try to do that succinctly. But I'm going to start with some caveats. First, obviously my observations are going to be quite broad, and there's lots of technicality, as we can see, in all of the discussions that we're opening up today, and I'm not going to be able to do justice to that. And secondly, I tend to use analogies, and sometimes those analogies become a little overextended, so forgive me if that happens. As Fleur says, my background in this space is very much from a sort of research and academic perspective, but I've spent quite a lot of time doing empirical work in the system. So I've spent some time doing work with policing and police processes, quite a bit in corrections and prison systems. And so my perspective, I think, is as procedural maybe as it is evidential. And as we see, some of those things are very interconnected. I think a lot of what I'm saying will begin by echoing some of the things we've already heard. So first, I would absolutely agree that the rules of evidence and procedure are, I think, fundamental regulatory tools, and they work to structure and to order the operation of our justice system. So that's not a trivial thing, even though sometimes, especially sometimes in academic circles, it's dismissed as an adjectival area of law. I think the effects of these legal rules are profound in the way that the justice itself is produced and experienced. And so these rules really do deserve careful attention, and I'm really pleased to see this review taking place, and really keen to see how it shapes up over time. So to extend this point, I'm going to invite you on my little analogy jaunt. So I want you to imagine the justice system as a kind of complex processing system, and it's designed to deliver justice efficiently. So evidence in this starts as a kind of raw material. We first assess it to see if it can be introduced into the machinery at all, and under what conditions. And once it's introduced, we extract components, we refine them, we assess them for defects or irregularities. Perhaps we reject things if they're not good quality. We combine some materials with other raw materials in the right order where it's appropriate to do so. And we do all this in the end, we hope, to produce just outcomes. So we could imagine procedural rules as rules that tell us how the machinery works and which govern the processes within it, including, for example, how our materials are collected and in the first place. Rules of evidence govern the materials themselves, so how to assess their quality, their authenticity, how to extract relevant components for them, how to refine and use that material appropriately. For this, and I think this point has also been made, we need good instruction manuals. So I know that's not a particularly legal way of looking at things, but I think it might be helpful. So as has already been, I think, fairly well highlighted, our manuals in Queensland are not particularly accessible. They're not as as accessible as they could be. So some parts of these rules are not written down at all. Others are scattered through a number of different statutes. Some instructions are not where you expect them to be, where you'd go looking for them first. On the whole, of course, most people who operate the machinery know how to do all of this well, and they know where to look for things. But this could be much more accessible to others, and for me as a teacher and for my law students, absolutely. And especially for lay people or for people who are actually subject to the system. I think that's very important. I think, as has already been noted, in many other jurisdictions, you find most aspects of evidence in the evidence law itself, and most aspects of procedure in criminal procedure rules. But even there are some really interesting variations. So, jury directions, for example, for us, where we've legislated, we've placed that into the Evidence Act. In other places, that sits in the Criminal Procedure Act, and in Victoria, it sits in a standalone act. I'm not entirely sure that we need to make a decision yet about whether that sits all in one instruction manual or whether we have 2 or 3 that interconnect with each other, where exactly we draw the boundaries between what is procedure and what is evidence when it comes to procedural aspects of evidence-related decisions. But I certainly would agree that we need coherence, we need clarity, and we need accessibility as we start to think about that. And in that respect, some of the arguments that you see about should we have a rules-based system, a principle-based system, a common law system, become quite interesting and I think still valid, and some really deep conversations that can be had about that. But I think there's a very good reason to think about procedural rules as being the best fitted kinds of rules to have in a statutory form, in as much as we can make that happen. How defined and how specific those rules are is probably the next set of questions that we really need to think about. So now I'm going to move on to my second point, leaving somewhat that tortured analogy aside, but saying, of course, that the justice system is, of course, not a machine. It's made up of human beings. So if it is a machine, it's a human machine. It's a machine made up of human beings, and most of the raw materials that we're putting into the machinery are, of course, humans. And so we have to be really careful not to let the machine damage humans as evidence is extracted from them. And I think that's been something we've really started to see develop over the last 10 to 20 years. This is good for the humans, actually, not to be damaged through the process, but it's also very good for the nature and quality of the evidence that we're extracting. That's the argument you see very commonly reflected in the kind of principles that appear beside special witness protections. So this is, like I say, an area where we've seen a huge amount of growth in the proliferation of special witness protections. We've seen intermediary schemes. We've seen these kinds of things develop, sometimes very specifically focused on certain particularly complainants in domestic violence, sexual violence cases, broadly for children. And I think there's a lot of scope to consider how we continue to think about that even for people who are accused of criminal matters. I'm obviously talking predominantly about the criminal justice system here. So because we know what the vulnerabilities look like across various different populations and how those vulnerabilities can intersect. What we also might really need to think about is how we ensure that that is an efficient and effective set of procedures, because there's a lot around those systems that front end what we need to do that can delay some of those processes and that can in themselves create all sorts of potential unintended consequences. So I think some careful thought about special witness frameworks is really warranted, and how that sits with evidence or procedure is an interesting question. We should also note, of course, that humans drive the processes. So it's not just that they're the raw materials, but we actually create the system itself. And so the decision makers at every level are very important. And we think a lot about judicial decision making, but decisions get made very early on about evidence by police, by prosecutors, by defence lawyers, by a number of different people, guiding and thinking about how we, I guess, curate those decisions, what kinds of frameworks we place around those decisions is a very interesting thing. That's great, because I have one last point to make. So I think that segues to my last point, which is about governing inferential thinking, which is really what evidence is about at some very fundamental level. So there's a growing tendency, you can see this is the final pattern that we're seeing in evidence law, both in Queensland and across other jurisdictions, to use rules to actively manage or curate inferences, and to put guardrails up that guide decision making and that ensure decision makers, especially juries, don't wander off course or down dangerous paths. Some balance is needed there. If you have too much curation, perhaps a jury simply rubber stamps decisions that have already been in some way predetermined by a set of decisions that have been made earlier in the process. But too little management, which is what we've sort of had to date in some spaces, might lead to the application of a common sense that is actually unfair, problematic, or erroneous. So we've been concerned about this for accused people for a long time, so how do you think about the inferences you draw from a lie, for example? But more recently, we've become much more concerned or interested in erroneous kind of inferences that can be drawn from the evidence of complainants or other witnesses, and try and put guardrails around a lot of that. Where do we see that? We see this in the growth of mechanisms like jury directions, like regimes or limitations on questioning, expansions of expert evidence that help to guide or to manage decision making. But we actually still know relatively little about what works and under what conditions to ensure that there is effective, good quality decision making being made in response to these kinds of measures. So I think that means we'd benefit considerably, and this is an academic kind of predictable academic thing, we can benefit considerably from working more closely with other disciplines. And particularly, I think, from the behavioural sciences, to understand better how these problems arise, cognitive kind of rational decision-making problems arise, and how to best address them. So does telling juries about information or providing them with better quality information actually help? Or are there other innovative ways that we can assist decision makers to absorb, to order, to process complex information? And so in that respect, I think rules are really important, but we need to make sure our rules are flexible enough to be able to use innovative frameworks or regimes to actually map to facts. And in the end, we need to know it's the mapping of rules to facts that actually creates a lot of the tensions and difficulties in the real experience or application of the rules of evidence. I think maybe I'm in time for my 3 points.
Yes, I've got my stopwatch going a little bit over, but you've done very well. You've all done very well. The breadth of the topics that have been really skated across and touched upon by the three speakers shows, I think, the enormity of the task that the QLRC faces in this evidence law review. And I was interested in the extent to which each of you talked about those structural issues and how important that is for questions of accessibility and clarity. So thank you very much, but your job is not done. We do have some time for questions, and what we might do, Matt, if you've got a question that you want to draw to the speaker's attention from the chat, then we might start with that, and then we'll take it. You've got, no, not ready yet? Okay. We're going to ask anyone in the room who wishes to either make a comment or ask a question to use the mic, not because you won't be heard here, but for the benefit of those listening online. Would anyone like to pose a question to any of our speakers? All right. While you're thinking of a good question, I'm going to pose a question to Justice Crowley. I know that he had other things that he wished to address in his presentation of examples of things that he thought were worth considering, were working well or not. Is there anything you'd like to add, Justice Crowley, to what you said earlier?
Yeah, a couple of examples. So the things that work well, which I think is part of the review, we'll be looking to see how and in what form it is retained, are things like the way in which evidence can be introduced from witnesses in particular categories, so affected child witnesses, special witnesses, protected witnesses, and witnesses who are complainants in domestic violence and sexual offences. So there's been quite a lot of work done to date already to reform the evidence laws in those respects. But just going back to an example which has been in the Evidence Act for quite a while now, under Section 93A, the statements that are introduced through of complainant children or child witnesses. And we see it routinely in the courts that the 93A statements in criminal matters are admitted as the evidence in chief effectively of those witnesses. And what it's done is it's enabled the quality of the evidence that can be given by those witnesses to be enhanced so that the court can now receive comprehensive evidence and account from those witnesses which they might not otherwise be able to do in a formal courtroom setting. And if we go back to when those reforms were introduced, there was opposition or reluctance to embrace them out of concerns that this might somehow affect the reliability of the process, or it might somehow undermine the rights of an accused person. That hasn't really been borne out, I think. In fact, what's happened is that it has enabled evidence that is reliable, at least in terms of its ability to be given as a full account and then subjected to scrutiny in the court process, to be facilitated. So that's one example of the things that work well. With that are the associated measures that can be taken for the pre-recording of evidence or other measures for witnesses in particular categories, all of which I think we would want to retain in our evidence law, but where it fits and in what form and how it might be expressed, they'll be things that perhaps the Commission will be looking at in some close detail.
Thank you so much, and thank you for your generosity in being very open with your views, Justice Crowley. I know that is an issue as a serving judicial officer to think through how you express your view on such matters. I know we've got a question online that Matt can pose.
Thank you, Fleur. I might direct this question to Beck. How effective do you think jury directions are, and do they actually help juries make decisions?
The answer to that is somewhat adjacent to my expertise, so I'm going to borrow from what I know from some of my colleagues in the behavioural sciences with whom I work on these kinds of subjects. It's a very mixed bag, really, in terms of what we can see. Partly, one of the problems is it's very hard to access juries to do good quality research with, obviously. So most of the things we do know about jury research comes from simulations of some sort. How well that maps to real experience in the first place is a question. We see that some of it has to do with broadly what it is that juries are given in the first place. So, you know, the kind of breadth of facts, what we've seen as being relevant in what's produced. And then we see some mixed results. So there are sometimes some concerning aspects to jury direction innovation that show that sometimes bringing the problem up in the first place or directing on something in the first place can make an issue out of something that might not have been an issue. Or that if you say, be careful not to do this, then people become perhaps so confused about what they should do that they just decide to do nothing. Certainly I feel, and this is my interpretation of an area that this is me caging my expertise in terms of over-explaining or overstating something. What directions really need to be careful about is being very fitted to the facts of the case in front of them. So rather than just generally saying I'm making a set of directions that might be relevant in cases like this, they have to be thought through for the way that they, which is of course what we're asked to do in that kind of framework. So I think there's a lot of scope to really think much, much more carefully about the extent to which directions can remedy things that might already be in play. And if we are going to remedy them via directions, how exactly and what conditions do they really work That's it's a burgeoning area of research, and one that I think would be really interesting to do much more in.
Thank you. We'll take one more question, and then I know we're right on 2, so we'll just do one more question, and then I will need to wrap up. Thank you, John.
Thanks, Emma. John Chesterman, Public Advocate. Following on in some ways from Justice Crowley's comments, I'm interested in the panel's reflections on the systemic implications of broadening out the ability of some groups to give admissible evidence, and I think particularly of, for instance, my area, people with cognitive disability, that broadening out their ability, people in that cohort's ability to give admissible evidence will have implications for policing and the collection of possibly admissible evidence. Just interested in the panel's reflections on those kind of systemic possibilities that this review provides.
All right, well, it's been thrown open to all of you. But Ruth, you haven't addressed a question yet. Is it something you would like to comment on? Don't feel you need to if you do not
Only
wish
to this extent, and my answer is not technical in any way. I think that we have shown as a community that we are not only capable of, but have developed and matured so much in recent decades in terms of our understanding of evidence, the reliability of evidence, and the importance of evidence coming from a whole range of people who have to appear before the courts. By and large, I think it's fair to say that until recent decades, if a certain person appearing as a witness in court didn't fit particular moulds and present in a way that was well understood by the mainstream, that there was a real risk that their evidence would not be appreciated in the way that it should be. My perception in the time that I've been at the bar is that we have developed a long way in terms of making sure that evidence of all people can be properly put before the court where that evidence is reliable and relevant. My answer to your question is yes, I think if there are different types of witnesses who require some different and particular measures to be put in place that aren't already allowed for in our law, then we should absolutely be looking at ways to strengthen that. And I think that that's something that the Commission is certainly alive to and will be wanting to address. And in order for the Commission to do that effectively, I think it will be really important if those sorts of issues are brought to our attention by the community generally. We're alive to a lot of them, but we can't be alive to all of them. And so from this discussion moving forward, I think it's fair to say we would be enormously grateful for people making contact and pointing out these sorts of issues so that they can be addressed.
That was such an excellent answer that I'm not going to ask anyone else to comment on it, and time prohibits me from doing so in any case. On the screen you'll see a QR code that'll get you to our landing page, I think is what we call it, for the review. And there will be, you'll find all our materials. There's also an email address. Please, if you have questions or comments or ideas, use that email address. If you would like to meet with us in person to discuss something, then also use those means of communication. Be as specific as you can, because we are a small team and we are doing a lot, as you can gather from the scope of this review. I think in closing, it would be remiss of me if I missed this opportunity to tell you about some of the things that we're doing in the review. And I'll start with John's question, because one of the things that we will be doing, hopefully, is consulting with John's assistance with those who have experienced the criminal justice system who have an intellectual or cognitive disability. But we're also engaging with so many other groups as well. We have got a focus on called communities. We are going to be doing a seminar in collaboration with QUT. There are representatives here today, and we're going to do that in NAIDOC Week. That will look at the issues about evidence for First Nations people, not just when giving evidence about traditional law and custom, but evidence generally. From next week, I think, or so, we will be in the regions doing a bit of a consultation roadshow, if you like. We go wherever our limited budget will allow us to travel. We will be going north, we'll go west, we'll go east, we'll go south. So we will cover the regions. We're planning roundtables on specific topics. One of the topics that we will be focused on is AI because of the challenge that that presents. And thank you, Justice Crowley, for reminding us of that colour issue, which had otherwise escaped my attention. We're consulting with experts, expert witnesses across the field, forensic and medical experts, but also those in other jurisdictions. And we also have two important consultative mechanisms that we're using throughout the review. We have a profession-based consultation committee, and there are some members of that committee here. Thank you for your time on that committee. We will be meeting regularly with organisations that have an interest in this area, and we're also liaising closely with the courts. There is an evidence law review committee that the judges have established to ensure that we're keyed into the experience of serving judges. So all of those activities are designed to elicit as much as we can from the various different perspectives of from those people who are affected by evidence law or work within that jurisdiction. All that remains for me in the time that I no longer have is to do some thank yous. My first thank you is to the team at the QLRC. We do a lot of things on the smell of an oily rag, and we're only able to do it because of our staff, who are amazing. I would like to do a particular acknowledgement of our newest administrative staff member, Kate Rotondo, who arrived and had to establish arrangements for this, but also there was a larger team, Natalie, Bob, and our Executive Director, Matt, and Julia Starkey, who does the communications for everything that we do so beautifully and so well. I want to thank our speakers, who have been incredibly generous with your time, with your experience, but also with your openness and sharing that with us today, and your aspirations for our review. There are a few topics I think we've noted down that we really need to go back and have another look at. And finally, thanks to all of you. You've given up your time on a busy work day, and we appreciate your engagement. I hope that we will see you again, and I look forward to working with you through the review. Thank you very much.